It is 6:02 on Wednesday, July 26th. We are meeting, this is a meeting of the Board of Selectmen. I will open. We're meeting in the basement, lower level of the Rutland Public Library. We are being recorded.
Recorded, broadcast live, available for remote access through Zoom, will be rebroadcast in the future and be placed on all of our internet services for providing video.
So there you have it. This is a joint meeting with the ad hoc bylaw committee. I don't think you guys have a quorum.
We do not, so I won't formally open.
Okay, so we can go ahead and start with the pledge, I guess.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Before we start in with the bylaw review, we had one late addition to our agenda, and that's for to approve one-day liquor licenses for Sunday, the 29th for, what, sorry?
30th is Sunday.
Oh, 30th, sorry, thank you. 30th, Sunday the 30th for Seven Sols and Lilac Hedge under the fire brigade. That's in case the weather is not looking great for the food truck festival on Saturday, and the decision as to what Mark and that team is going to do is a little bit up in the air, and it'll probably be a decision closer to the time. So if they need to postpone until Sunday, they're looking to potentially have the opportunity to have the one-day liquor license for Sunday if necessary. Because it's kind of weather-based, and everything's up in the air. For this instance, I think the hope was that the fees would be waived because it's kind of an extenuating circumstance, and all the paperwork and everything was already in for that first. The intent was that it would be a one day.
Yeah, we were just chatting about that and making sure that the way the motion's worded, it's Saturday or Sunday, whichever day the event is held, that it's not an additional license being issued for Sunday.
Yeah, that it's for the rain date.
Would this be if the event itself was canceled, not just that they don't want to show up?
Correct.
They're going to do it themselves.
Correct. My understanding is that if the event is held, the intent would be if they wanted to be there, they would be there. The fee is collected.
Yes.
Oh, sorry, Tamika, go ahead.
Tamika. I'm sorry to interrupt. So I don't know if you saw Mark Allen's email today, and they're talking about there's a possibility that they might postpone altogether, or they may split people up between the 2 days. So my only hesitation is that I would feel more comfortable if we approved them for a second license for the 30th, and then they could potentially do both dates with the understanding that that would also count against one of their one-day liquor licenses for their calendar year total. Unless the board feels that they want to restrict them to only one day, I just don't know which way they're going to go, if they're going to postpone altogether or push it or split between the 2 days.
Yeah, I'm looking at the email now. Thank you, Tamika. And it looks like if they hold it on Sunday, there would be the opportunity for, they have 22 trucks scheduled to come, and if they held it on Saturday, all 22 trucks would be available. If they held it on Sunday, only 13 of those 22 trucks would be able to come. So I think it seems like one of the considerations from the food truck, the Mark who is running the Worcester Food Truck Consortium and kind of doing the food truck festival, is to either just take the chances on Saturday alone, or run it on both days. So since about half of the trucks can't come on Sunday, they would have the opportunity to come on Saturday if they felt like fighting the weather. Mm-hmm. That does make it a little bit more murky as far as the license approval and everything. I think to Tamika's point, it would be maybe more beneficial to add in the second day. I don't know, I haven't heard any communication from the fire brigade. This has all been kind of just happening because it's weather-based. I don't know what the fire brigade's intent is, if they would intend on being set up at both days or just being set up at one day. I don't have that information. Austin, I don't know that you have had any communication. I know it's kind of been an as the day has progressed kind of thing.
Leah, they have been looped in on all these emails, and I did also loop them in on the as far as what we're playing with the one-day liquor licenses. And Randy confirmed receipt of the email, but they didn't give any indication one way or the other what they were thinking of doing.
So what happens if we approve a second one for 2 days and they only show up for one? Does that go back into their balance, or is it considered used?
Tamika, what?
It would be considered used because it was issued, but in all honesty, I think these two vendors only have maybe 4 total out of the 30 you can have in a calendar year. And given that we're more than, halfway through the year, I really don't anticipate there would be any issues with them coming close to maxing out. Because Seven Swords is from out of town and Lilac Hedge has their retail liquor license. So this is really only comes up when there's like a particularly special event.
So that's the information that I've kind of been looped into throughout the day, and I think Tamika, you have the most relevant information as the point of contact for everyone. So before us is to, it sounds like the preference based on the most recent email correspondence with Mark is to add that second day, the 30th, as a second day for the for Lilac Hedge and Seven Saws. So
Do we waive the fee?
I think, and I think this is up for board discussion, I think originally my gut instinct was to waive it for that second day because it is weather-based, and their intent originally was to do the one day. And not having had any input or heard back from the fire brigade as to what the fire brigade's intent is, but again, I'm happy to have the conversation with the board, like.
If I may,
Yeah.
if the event still goes on Saturday, then they've already paid for that. If it's canceled, then they go to Sunday and they've paid for that because they never got to use it. But if they show up for Saturday and Sunday, which we do not know what's gonna happen, but if they do show up, then we simply, in my opinion, we charge them in arrears, $60. I'm not asking for it now. If they don't show up, they don't know anything. If they do, then they pay the $60 if they want 2 days there.
Can it be paid for after the event,
That's what I mean. in
I mean,
arrears,
I
yeah.
think
technically?
Tamika, I think it's a preference thing. I think there's no guarantee that we would, it's the honor system at that point. Typically, we usually ask for the fees in advance before issuing the license, but to your point, Harriet,
If I go to that food truck and they're there.
Yeah.
And, the consideration is you don't pay us. And now the next time you're gonna ask for a license.
Yeah, well, and it's a precedent thing too. Is this a loophole that more are gonna start understanding and
Right,
taking?
and, if it wasn't for the weather, we wouldn't even be considering this. So, but that's,
Through the chair, these food trucks make a ton of money.
so it's not, I mean,
I pay the fee, and if they don't show up due to that, then I say get the money up front, and then we'll cut you a check after that. I don't know, that's.
so it's not for the food trucks, it's just for the one-day liquor licenses for Seven Saws and Lilac Hedge.
Oh,
So
yeah.
they've already paid they've paid one fee for Saturday, and
Right.
the license is issued for Saturday. I think generally, they usually try to hold the food truck festivals, rain or shine. But given that with the current fluctuation in weather and potential for severe storms throughout the weekend, I think that's the consideration as to they may actually have to either cancel or postpone or shorten or something like that. So
But that wouldn't be our fault.
No, 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 no,
Yeah,
I'm just,
I
but
mean,
I'm just,
That's the nature of the business, isn't it? I mean,
Well, and assuming it's a single event, I mean, what happens in that case? Do we issue refunds for licenses not used, or do they transfer for a different day?
generally,
I think that gets messy. You know, now we
So
gotta
it's-
worry
Yeah.
about who didn't and
I
then we're
was just
giving the money
thinking
back.
the
Well, no,
same
I'm just asking if, you know, under other circumstances, is
Oh.
that something that we would do?
so I know
Has the
in,
board ever come across this
We have
situation
not
like
in the-
that? Tamika?
The only time, no, we've never issued a refund for a one-day liquor license if an event, like a 4th of July event got rained out or something like that. The only time we've ever issued a refund is if, say somebody applied for like a common vic license and they didn't end up moving forward. In that case, we've refunded it, but never for a one day.
so I guess it seems like the board is amenable to issuing a second license for Sunday the 30th, but would like to have an additional fee collected. Is that the board's?
I mean,
think
yeah,
so.
it's not the town's fault.
Yeah.
Right,
So
no,
I don't
no,
understand
yeah.
why the town is, yeah, I mean, that's the nature of the
Well-
beast. If they unfortunately have to get a second one for the next day, then that's on them. I mean, they're gonna make.
Yeah, I mean,
I'm sorry, I don't mean to interrupt you guys. It's hard on Zoom. So I was just going to ask if the event is say totally canceled on Saturday and they have to push it to Sunday. I presume we would not charge them a fee because we already collected it for the day that they didn't use. However, if they get to work for the 2 days, we would ask them. I can ask them after the fact. For the 60 days, which, they're both very upstanding businesses. I'm certain that they would pay the fee if necessary. And I can process that after the fact as well. Would that be acceptable to the board?
Yeah, I mean,
Just-
Works for me.
I'm okay with that.
yeah, I'm good with that.
Okay. I think that's the board's amenable to that, Tamika.
Okay, so what I'll do is I'll reach out to them both tomorrow and I'll loop in the fire brigade just so that they understand that if they choose to participate on both days, if that's what's possible, they will have to pay a second $60 fee. And then that way they'll know ahead of time and they can make the decision if they
Yeah,
want
if
to do
they're
that or
both-
not.
Yeah, if they're at both days, then we need an additional fee collected. So,
That's fair.
I guess
Okay.
we would need a motion to, issue those two entities a one-day liquor license for Sunday, July 30th. And ask if they're in attendance at both days that an additional fee is collected.
Yep, that's perfect.
Making the motion?
I will accept that motion.
Okay.
Is there so moved?
I'll make the motion to approve the one-day liquor license for Lilac Hedge and Seven Saws Brewery for Sunday, July 30th, for the food truck festival at Naquag Elementary, with the understanding that a second $60 fee will be collected if they attend both days, Saturday, the 29th, and Sunday, the 30th.
Second.
I think that's what we need, right, Tamika?
You killed it, Jen. Good job.
Yeah.
Very impressive.
All right. We had discussion. Is there additional discussion? Roll call, Harry.
Second, aye.
Matt's and I.
Ledger I.
Galvin I.
Whitman, aye. Thank you. Thank you, Tamika. And that was added,
Thank you, guys.
I mentioned it at the beginning, it was added after the original posting just because the weather became a bigger concern, so that's why it was a late addition to the agenda. Moving in now to the bylaw conversation. We have here Peter and Norm from the ad hoc bylaw committee, and we can get going.
Okay.
Through the chair?
Yeah.
Just a question to think, if you're going through this, maybe you can clarify this. In your ad hoc bylaw committee's charge sheet,
Mhm.
you listed that it's based on looking at all the mass general law changes.
Yep.
Case law that impacts and current practices.
Mhm.
And then you lay out the process by which you do it, which is review by a subject matter, review by the select board, and then legal review by town council.
Mhm.
Did that get changed? Legal review first before it comes to us?
That has not been changed because if you look at what happens, it's a public information session.
Okay.
If it's already been reviewed by subject matter experts, people who know the law and are responsible for its implementation, it's not that something can't come up in the public information session. But when that happens, there is more work to do to bring it forward. It's not, I would not say we would not accept input from the public, but the intent of the session is to inform the public as to what we are proposing.
And I will add, a number of these bylaws were already seen by the previous select board.
Okay,
So they've been kind of through, it's been almost a year and a half, Peter, since the previous
Thereabouts.
select board had started review, and there were questions, significant questions about some of them that I think then went back to Peter and legal, for clarification.
Correct.
So just as a,
do we know which ones they are?
So do we have a history
I will
of-
point all that stuff out.
Okay,
Okay.
perfect.
I would like to try to keep the bylaw conversation to about 2 hours, so looking to end about 8:15, 8:20-ish. And as far as we can get through this part, tonight, and then Monday we will pick up from there and again, try to dedicate about 2 hours. I think all of us turn to mush after, 2 hours.
And I know I am basically a fire hose of information overflowing. It's the way it works, unfortunately. So when you folks are ready to stop, we'll stop. I'm one of those Energizer bunnies. I can just keep going for hours on end. I have a saying at work that I can talk for an hour about anything, whether I know about it or not. This stuff I know about, so I can go for really long periods. One thing I want to tell you folks now is that the format of this is the format of the public information session. We flow through, we discuss the changes, we see what's happening. And all the discussion that happens is the discussion that happens. You folks will get a little bit more because, I mean, especially Leah's been through this a couple times, and there are some things I want to try to remember to specifically point out about changes since she last saw them. But a lot of this is going to be new to all of you, so we're going to start at the beginning. Unless there's a question. Oh, I will say, for those of you who don't know, Norm Anderson, who is not only the vice chair of the ad hoc bylaw, wait, are you? Yes, you are. You're the vice chair of the ad hoc bylaw committee and chair of the planning board. Everybody on the bylaw committee, ad hoc bylaw committee, is extremely helpful because we have such a diverse set of information. I know where I come from with my histories. Norm has his experiences and his knowledge. Anita with hers. Lynn Turcotte is an attorney, and Ron Kent with his other background. We're pretty widespread, and I'm impressed with all the output that we've all done. So let's start, if you don't mind, at Chapter 1, Article 1. Things I'll point out in the final book form is that everybody knows where they are in the book. It's one big book of stuff. We have started to call bylaws articles. It's a fancy term. It doesn't mean anything other than bylaw, but I'm tired of seeing the word bylaw everywhere. So everywhere it says, where it would historically say this bylaw contains, it now says this article contains. Article 1, Chapter 1 is the foundation of the universe as far as we are concerned, because what's in here applies to every single bylaw in the entire book. Now, in some ways, it could make it a little more confusing to people. Here we have a definition of a day, a calendar day, and a definition of a working day. By putting it here, I don't need to have those definitions in every bylaw that uses those terms, but in order to know what a working day is, you have to know to go to the definition section of the bylaw that you're in, and then to the general provisions. It's an unfortunate artifact. We chose to have these few here because these terms are used in enough bylaws to make sense to not have the repetition once or twice. I know I vaguely remember talking about this in my last presentation. Every bylaw has a purpose, it's nice and generic, and we try to not make it flowery. We're going to protect the town by whatever. It's basically what the bylaw really does, and then authority, which is what allows us to write this bylaw. We will always reference one section of general law or multiple sections of the general laws and or Article 89 of the Massachusetts Constitution, which is the Home Rule Amendment, which is what allows us to write bylaws that aren't explicitly enabled by other sections of Mass General Law. Very little to say here about these definitions. I think they're straightforward.
I have a question.
Please feel free.
A question came up last night with the Historical Commission regarding quorum.
Mhm.
They weren't sure.
Mhm.
Was there a reason maybe in the definitions that quorum wasn't included in there so everybody knew what a quorum was? 'Cause
Quorum is defined by Mass General Law as 50% plus one of the size of the body.
I thought there were two definitions.
No.
One was if your body is 5, like the CIPC, then your majority or quorum would be 3. But if you're at a meeting and there's only 3 people there, the quorum would then be 2.
No, that is not correct. The quorum is always 3 for a 5-member body. Always. Small exceptions for variably sized bodies like the 4th of July committee. But for established committees, the quorum is fixed by the number of seats divided by 2, rounded up to the next whole integer. Now, what you might be confusing or conflating here is not quorum, but majority.
No?
Because when you're voting, let's just say you're accepting minutes, even though so if the quorum is 3, you can't meet with fewer than 3 people, period. But you can have something that passes with only one person voting if you were only 3 people there, and 2 of them abstain, only one person's voting, and that's still a majority. Because it's a majority of those people present and voting.
I mean, it came up because they were confused about it, that's why.
Yeah, I think the confusion was because there's only 4 of us that are actually on the commission now, and we have to have all 4 of us present for a quorum. We can't, 3, like, as the majority doesn't count because we're still, right, as of Monday now, a 5-member board, but
Right,
we still require.
that was it.
As of then, when it was 7, we had to have all 4 of us. Now that it's 5, it would only be 3.
Now it's been relaxed. Now one person can be absent
More
without causing a
relaxed.
problem.
Yes.
Okay.
Yeah.
All right.
Okay?
Mhm.
I have a question about definitions.
Yes.
And this might be an Anita question, I'm not 100% sure. I understand the town official, so it's any town officer, employee, or member of a committee, whether elected or appointed.
Mhm.
I thought there was something about town employee, more so from the perspective of open meeting law and ethics and everything. So even technically, any at minimum, any elected official is considered a town employee for certain situations. And I'm not 100% sure if that extends to appointed boards and commissions. And it wasn't based on if you're taking salary or benefited, it was more
So what you're talking about gets very confusing. So let me see if I can try and answer it succinctly. An appointed board committee member is an employee of the town for for application of certain sections of MGL, like the open meeting law and conflict of interest law. But that is not the usual meaning of the term employee. So, and if you look at employment sections of MGL, it gets even more confusing, but generally speaking, for most applications, you need to be drawing a salary, not even just a stipend, but a salary to be considered an employee, depending upon the section of Mass General Law you're trying to apply it to. For conflict of interest, there's no question, everybody in this room is an employee of the town. with regards to that particular Mass General Law section. It's very confusing because there are different meanings of employee in different contexts. So I don't know that I actually answered your question.
And I guess my getting to that point then is, should employee be, because I know throughout some of the bylaws, it references cannot be an employee, what that context of employee means, in which case. I know FinCom is very explicit, I think even CIPC is explicit, as far as memberships of those committees, cannot hold other positions or employee, and I forget exactly the wording between those two different entities, and I think that there were a couple other ones also. And so I'm wondering if there needs to be clarification in here for that going forward.
We can talk about that in the committee. There seemed to be no confusion from town council, but I'm not saying there can't be.
Okay.
So we'll bring it up at the committee, at the next committee meeting.
And I mean, if it's been addressed with town council, but maybe it can be better clearly
Sure.
somehow.
I will say, we have written words about employment 5 or 6 times. And we end up stripping them out because they end up not actually serving a purpose to the bylaw. So,
And like I said, it's more so some of who can serve on what committees or what additional work those people could do if they're on a certain committee. So that was my question.
and I think what you find as we get to specifically CIPC, you'll find that we have changed words from not being a town employee to not employed by the town, which is a very different phrase, which I think helps clarify that. So if we're careful about how we specify that in each of the bylaws, I think it will become more clear also.
That's another way to handle it. Thank you.
A note about the word committee. Any appointed multi-member body of the town. So when you see the words "a committee," it could be a committee, a board, a council, any of those multi-member bodies. When it's "the committee," we mean that thing that's probably called a committee properly. So you will occasionally see a generic "a committee," that's what we mean, it can be any committee or any multi-member body of the town. I don't know, there's a lot more to say other than our working day definition does specifically excludes Saturdays, Sundays, and holidays, because when we get into the number of days between when one action takes place and another action must take place, sometimes we want to be very clear that they are working days, because you don't want to include the weekend days in a 5-day schedule, in a 5-day timeline.
I have a question on that,
Yes,
and it might be nitpicky and not necessary, but
sure.
do we need to specify federal holidays versus?
No, we don't, because it's town holidays.
Okay, do we need to specify that?
I don't think that we need to.
Okay,
I mean, we can. I don't think there's a harm in doing it.
so any holiday the town, a
Observes.
holiday the town observes are
Yeah,
days, okay.
something like that.
Okay.
Okay?
Peter,
Yes, sir.
stupid question, I'm sure. A lot of our employees have off on Fridays, so it's not really a working day.
Friday is still a working day of the town, though. Town offices are open and they are available certainly by appointment and sometimes by walk-in. So Friday is not a day off from the town. It is absolutely not a holiday.
I think a lot of our employees do work many work on Fridays. It's just not necessarily open to the public as a come and go as you please open to the public.
Exactly. And oh my goodness, can you get work done on days like that?
So, yeah.
I mean, when somebody who's not involved reads something like that and they say, well, the offices are closed Friday, is that not a working day? So that's where I came.
Right, and the fast answer is, even if the town offices were completely closed every single Friday, by this definition, that is not a holiday, it's just a day they're not working.
Okay.
Which may go back to Jen's suggestion about changing the terminology about holidays the town observes. Moving on. Uh-oh, you're not. Oh, that's because I'm not focused. There. Oh. What did I do that time? There we go. The kind of text in section 4 has been there all along, been there for a long time, I should say. A number of years ago, this basic language was added, saying the town can adopt and change bylaws all they want at town meeting. And the town clerk has certain non-substantive change powers. All by herself, she can make decisions to renumber things, and that's it.
Is it a majority or 2/3
What's that?
for town meeting approval?
Town meeting for general bylaws is majority,
Zoning is 2/3.
yes.
Zoning bylaws, you mean?
Yeah,
Okay.
yeah,
got
sorry,
it.
yeah, yep.
To change your bylaw, it has to be on the warrant.
Yes.
Okay.
Yep, there's the whole process of getting it through this body to get it onto the warrant so that it can be voted at town meeting.
And I think, correct me if I'm, there may be some MGL-based exclusions as to what does need to be 2/3, but I'm not 100% sure if they're bylaw specific. I know that there are some other things that do need to be 2/3 vote, that's usually set by MGL.
Right, exactly. MGL determines that. So we just generically say, in accordance with law, and whatever those exceptions are for 2/3, the law says that's what we do. Now, a little history. There was a bylaw called the Non-Criminal Disposition Bylaw, passed sometime in the early 2000s, that was enabled by a new section of Mass General Law, Chapter 40, Section 21, that allows for non-criminal disposition of violations of law. Instead of this going to court and getting the whole court case and doing all the criminal proceedings, instead, the police department can directly issue fines that need to be paid. They have, in fact, the town made little booklets for these things. So the town did adopt that. What the bylaw committee did is took the important parts of that bylaw and moved them all into this general provisions bylaw. And the fine table has been moved to a completely different section of the book called the Schedule of Fines. And by the way, it's still part of law. It's still something that you need to go through town meeting to change. But that is one of the things that we'll be doing. The motion for this will include adopting this bylaw amendment as well as repealing the non-criminal disposition bylaw and adopting the fine table. That's all gotta be one motion because it's all gotta happen at the same time.
And the town adopted, MGL Chapter 40, already? Like the town has already adopted that?
Yeah, there's a whole bylaw for it today.
Yeah.
Yeah.
I just, for
Well, in fact,
clarification
it's not that the town adopted 4021. It's that the town created the bylaw, which is enabled by 4021.
So this non-criminal disposition has to be repealed at town meeting?
Yes.
Okay.
That's what I'm saying. The motion for this article will be to adopt this amendment, repeal NCD, and adopt the fine table all at once, all in a single motion. Now, the text here fundamentally is the same as what was in the non-criminal disposition. We've extended this slightly. It says any bylaw, regulation, or rule may be enforced through any means that the law allows, which will include criminal complaint, civil complaint before district court, or non-criminal disposition. Those are actually the three enforcement actions the police can take on any violation. We're just making it very clear to everybody involved, those are the three paths.
Well, I have a question.
Yes.
On your non-criminal disposition, okay, the police department has been enforcing a parking ban taking during the winter months into November through April, I believe it is.
Mhm.
And so if you have your car parked on the street and it's snowing and they wanna plow it and they can't, okay, you get ticketed. So, all right, so that is basically the way it has been. Now, it sounded to me like you were suggesting change to this.
No, there's absolutely no change. There's already non-criminal disposition. These options have always been available. What we're doing is we're making them explicit in bylaw, the different paths, so that anybody who says, what can you do? What can the town do to me? Those are the things the town can do.
I got you. All right.
And how each one, by the way, you mentioned a specific parking ban, so that is bylaw, so that can be enforced through non-criminal disposition. But if the police thought it were important enough for some reason, they could take them to criminal court.
All right.
B is mildly subtle if you're not paying attention, but boy, is it important. So every time that you do an illegal action, every time you rob a store, it's a separate offense. That's pretty obvious. But when you have something that goes on and on and on, like stormwater, infiltration, I&I into the stormwater system, where there's a fine for that. It's not just, but it's it seems like a single offense because it's a single time that it started happening. Every single day that an illegal condition occurs is considered a separate offense. That is already the law of the land. It's just made very explicit here.
So the issue that Dick brought up in regards to the motor vehicle.
Mhm.
So if it sits there for 100 days, each one of those is considered a separate billable or
Separate fine.
separate fine
Fineable event, yes.
for those days. Okay.
It's time to start keeping track of things.
I guess people start being aware, okay.
So again, this doesn't represent a change at all. This just represents an explicit statement about it.
Oh, can you back up a second?
Yeah.
You said when the violation exists or occurs, would that be the date that it is noticed by?
Yes, it's always the date it's noted. It's discovered. You can't say, I think I remember this 5 days ago, so we're gonna fine you starting 5 days ago. No, if there was no violation issued, if a violation issued on a day, nothing before that counts for this.
Well, I'm
Unless you can reasonably, humana can prove humana.
just confused.
Yeah.
The neighbor doesn't like it, if police finally get there and they say, well, that's been going on now for a year. Doesn't matter.
That's correct.
It'd be hard to prove. It's not like an inspection sticker. Your sticker says June, you don't get
That's
the
right.
sticker.
You
till
know that
November.
you were owed June 30th, that
It's hard.
before July 1, you were required to do it and you didn't do it. But for most of these things, do I think this will ever be enforced that way? I think it can be, because sometimes it can be a valuable thing to the town to say, this action we cannot tolerate. And so you'd want to do it, but unregistered motor vehicles may be only a one-time fine because they just needed to be corrected.
Or towed.
No, you can't do that. If it's on private property, the police don't have the authority to go to that place and remove it. So the owner would have to have it removed,
Or face getting fines.
or face getting fines every single day that it can be observed from the street, or from a neighbor's house that
The
will
way
let
the
you on.
police could touch it is if it was impacting the community
If there was
somehow, right.
lots of safety concerns that override that, but in general,
Yeah.
Okay.
And I think this is difficult enforcement. I know but even before I was on the board, there were concerns about certain properties in town that had fallen beyond repair or were becoming dumping grounds or whatever. And I remember the long ongoing battles as far as, even though the fines are being issued, people
Right.
aren't gonna pay and might not have the means to do the work or pay or whatever. So this isn't just a guarantee. It's,
That's
there's a lot
absolutely correct.
to it, so.
Every condition's unique, every situation, I should say, is unique. There are lots of reasons to do something, there are lots of reasons to use your powers to not take an action. Sometimes that's as important. But it all has to be situational, really.
I'm curious on that though, for an example, if it's just a property that somebody's just not paying whatever fines. If that property were to sell, is that something that goes on record?
Could be a
That the town, a
lien.
lien, yeah, that
The
the town
fast answer
owed?
is no.
Okay,
Well, the long answer is far more complicated. We learned about that recently in the bylaw committee. There is a mechanism, if you have the right bylaw that we don't have, to enable making a lien on the property for any town charge. But it's a little more complicated. The only case we put it in the current bylaw set is about stormwater. When we get to stormwater, I'll talk about all that and why that one in particular, but it is a consideration for the town to think about making the bylaw that would enable turning certain town charges into property liens. As it is right now, they can't be property liens, they can only be charges that someone pays or doesn't pay, and we can take them to court and but if they're not paying the town, are they gonna pay the court fees? I don't know.
well, it's something to consider because, there may be cases where, a couple $100s worth of a fine isn't gonna be worth it for us to take something like that to court. But if it's thousands of dollars that we could put on a lien at
Yeah,
our
if they don't answer the
discretion,
court, bench
Yeah.
warrant goes out, they get I mean,
Right,
it
right.
starts to
Yeah.
snowball.
It does
Yeah.
progress pretty quickly.
It's not something you can just say to hell with it and walk away. Eventually, it's gonna catch up.
Right,
It'll,
so-
you know,
might be something worth considering.
yeah.
Ready to move on?
Yes.
So we specifically call out that there's a new schedule of fines. That's where you find all the fines. And here's a new one. If there's nothing in if there is a violation of a bylaw that is not listed in the schedule of fines, it's $100. Period, for each and every offense.
I was gonna say, for each one, so
Yes.
each day that an offense exists would be,
Yep.
We have a schedule of fines for this.
Well, we have a schedule of fines, but not every single bylaw has an entry in the schedule of fines.
No, but in the old bylaw, it says up to $300.
And that's illegal.
I know it has to be a minimum of 100, I can't.
No. It is illegal to have a fine that is up to an amount. You must fine a certain amount of money. So we can't say, if you do something wrong, we're gonna fine you as much as $300. That's illegal.
So if this applies to other things, not this bylaw, that $100, then what is it for this bylaw?
If it's in the schedule of fines, it's whatever the dollar figure is in the schedule of fines. If it's not in the schedule of fines, it's $100.
Okay, I guess we're gonna have to wait till we get to the schedule of fines then.
Yep.
Okay.
default fine.
Huh?
Or something, it's a default fine.
Well,
Exactly.
I mean, to me, yeah, even $100 for something is right. I'm sorry, it's minimal. I mean, if you want some pain there to get the issue resolved, you gotta make it a little painful for
I would
me.
argue $100 is painful for some.
For a number of people, $100 is painful.
If you have an
Not for
unregistered
everybody.
vehicle on your property, it's not for the heck of it. You
Right.
probably
Right.
can't afford to register it or.
And you're
Right.
getting $100 a day plus the towing fee and
Yeah.
disposal fee and everything, so
It's more deterrent, I think, most of it.
Exactly, this is we needed to specify a value. Now, Harry's thinking about a higher number. If you guys think it should be a higher number, we can change that. Hell, I'd have to pass that through legal review, as far as I'm concerned, as long as it's not more than $300.
The people that are going to do this are not gonna be deterred by $100, in my opinion. Okay, if you have your car that's been sitting there for 3 months, dilapidated, you can't do anything.
But Harry, there's nothing more powerful than a paper trail. And that's all this,
Well,
this
and-
starts the paper trail, because if you can't pay 100, you make it 10 grand, they're not gonna pay the 10 grand anyways. It's more the legal action, I would think, following this.
That's all I'm saying, if it is, then
Yeah.
I didn't like 300, but I was thinking 200, not 100.
Well, and Harry, it's not $100 flat fee, it's per violation, so if that violation exists for a month, it's $100 per day.
Yeah, if the
That
car's there for
violation
5 days,
exists.
it's $500.
Right.
Because
I
as long
know.
as it's observed.
But I think,
And, by the way, back to our definitions for a second. I'm not gonna pull up the definition again. Oh, I went much too far. Each day, it doesn't say working day. That's 7 days a week.
but I think for the sake of the people that really are hurting, I don't know. I don't think it's necessary to.
Well, I think if we're gonna consider a different one, we're gonna need to look at the schedule of fines to see what's there.
Right.
And what are potential fines for offenses that are not listed.
Yeah.
And Is $100
A
okay
day,
for those
$100 a day.
offenses, or like, are they minimal compared to, I would assume schedule of fines has those that are, I don't know what I'm trying to say,
More detrimental.
Yes.
More
Yeah.
serious.
yes,
Yeah.
more serious, which would carry
Right.
a higher fine, but.
I mean, my take is kind of $100 a day is not so astronomical that people that legitimately could afford it can take care of it in 1 to 5 days. That 5 days is still gonna be $500, that's a chunk of change for a lot of us, right? Whereas the people that legitimately can't afford to handle the issue that they're being fined, $100 a day is just going to continue to set them
To a
even
mess.
farther
That's
back.
right.
Because they're not going to be able to pay the fine because they can't take care of the issue, and it's just a revolving thing. So that's my personal take, but I understand, Harry, that you would like something with a little bit more oomph
A little more
behind.
teeth to it. Doesn't
no, I
have to be
understand,
300, but it should have a little more teeth, in my opinion. I mean, when you're driving down the street and you see this old car sitting there and you see it all the time, these people don't really care to do anything with it. They're not gonna do it. So $100, they're gonna ignore that anyway. So if they're gonna ignore it, make it a little more painful for them. That's just the way
But if there's no recourse for us to collect it, or it's gonna cost us more than the fee in the end is worth, it's not gonna make a difference, whether it's $100 or $300.
that's what I'm trying to say. So why not make it 200 if it's not gonna really make a difference? At least when they get the notice and it says $200, oh my God, versus $100 a day, okay. I mean.
Frankly, it would be my hope that the usual behavior of a police officer would be a knock on the door and a friendly, hey, you know, this is a problem, would you please take care of it before you started issuing fines? So that everybody's aware of everything. So, and it's still, I assume that there would still be a report from that, so that there is still a paper trail that it exists. Is just the ability to fine is not a requirement to issue a fine at every opportunity.
If you're doing a title search through RMV, those have been known to take time sometimes. So in other
sometimes.
words, you know, it's a cascading thing that way.
I mean, I'm not stuck in the 200. It just seems like there's not enough pain there for somebody who is deliberately just ignoring things.
If they're deliberate. Well, I mean, that's a case by case.
Yeah.
Well, if you've got 10 cases, I can't believe
I've
every 10
responded to a lot of houses over the years, and there are people that are hurt.
Yeah,
There are people that are hurt. Yeah, you're right. Some of them are just a middle finger in the air,
right.
but that's not everybody.
And they're gonna
They're-
sit there and let it go for a month, and that's gonna be
Yeah.
$3,000
Yeah.
that has more teeth than $100, the one-time $100. So it is $100 a day, so even if they sit on it for, like I said, a month, that's $3,000, that's gonna be painful, but the $100 is still painful to the folks who legitimately can't.
If I'm showing my hard side, sorry about that. You
No,
know,
there's
I just-
nothing wrong.
No.
I understand your point.
Yeah.
I just,
Austin, did you have something?
Yeah, just one of the other mechanisms we have for reminding folks about their unpaid balances, if you will, is if they're applying for a permit or a license. And that's just flagged through the treasurer collector's office, where they are then notified, no permit or license until you pay your
Are
balance.
you talking primary, like a driver's license or?
No, the town
Any
licenses.
of the licensings that we
Licenses
normally
or
issue?
permits or
Okay.
anything that. we-
Hunting, burning, building,
Yeah.
anything the town issues for licenses does have
Okay,
the ability to be stopped if someone owes the town money.
okay.
Any department head may delegate, I'm sorry? Yep.
I wouldn't wanna make Peter wait. Should we decide on a dollar value so we can move on? Is that appropriate, Peter?
If you like.
So.
Should we see the list first, or?
Make a motion.
The list is pretty long. The schedule of fines is,
I personally am okay with 100. I don't know
Yeah, it's a hundred
How
a
the
day, I'm comfortable with.
rest of the board feels. By all means, I don't know that we need a motion because
Yeah.
it's a conversation.
no, this is a conversation, and this is sort of the view of the board. It's not, I'm certainly not looking for a vote of the board for this, for anything we discussed tonight.
We can make note of it and come
Right,
back to it
We
when
can
we
go-
get
that's
to the
right,
schedule of
absolutely.
fines.
right.
Okay,
We have sessions. We'll keep going. E, we added, any department head may delegate enforcement authority to any employee of that department. It makes a lot of sense, because a lot of things talk about the chief of police, and you want or the fire chief. You want that to be delegatable. Now, you're also limiting it to the employee of the department. So the police chief couldn't delegate to Norm, who's an employee of the town, but not of the department.
Most departments have an OIC, so
Yeah.
whoever the officer in charge is of the shift, I mean,
Right.
they're still, all depending on what decision they're making.
Mhm.
There's still a chain of command you have to go through, but
There's usually a chain of command, and what we ideally don't want is a holdup because the department has the enforcement authority, and God help us, that position is vacant. DPW, who I know isn't vacant now, but that's just, for a long time in my eyes, that position was vacant, and if there was no delegation authority, it could become a problem when he she goes away on vacation, when she just isn't available for any reason. So I believe that the delegation power is important when it comes time to actually enforce.
I have no problem with that. My concern was that word, any employee.
I don't know that there are other words in there that would clarify it, because how do you, anything that you try to add is going to need definition. A qualified member of the department, what does qualified mean? For what, and how do you define what qualification is, and how do you ensure the qualification is
And
managed?
even next in charge, because oftentimes
It
it's
flows.
seniority, or it's everybody's at the same step, or there's 3 or 4 people at the same step or whatever, then
like with the
Now-
police department, generally speaking, it's rank.
Right.
And then say the sergeant would be next in command or lieutenant or whatever, if they're not there, it's typically, generally speaking, seniority. So you'd be the senior officer.
And now, let me give you the problematic example. We have talked about this. According to that, the police chief can delegate authority to his secretary, which is of course silly on its face to do. And so rather than trying to come up with all these words that we could never adequately define, we decided best practices and the professionalism of our department heads is going to rule here, rather than over-specify.
Yeah.
Yeah, if you rely on your department heads, I mean, that's who we
Yeah.
hire when we put in charge of these departments.
This should not be one of the many micromanagement
Right.
techniques. Bylaws should not be that.
Right.
And this was already in the last one, any police officer of the town is empowered to enforce any bylaw, this is new, regulation or rule. If we got a rule or a regulation or a bylaw, a police officer can always enforce. We just expanded it to regulation and rule because it doesn't make sense. They're all They're all a matter of law of one level or another, yes.
Okay, town bylaw, regulation or rule. Would a policy be a rule?
No.
A regulation?
No.
Okay,
A rule is a specific thing, much like a regulation that goes through a process of adoption by a body. Now, a policy also goes through a process of adoption by the body, but a policy is not a rule because a policy is nothing more than a series of guidelines. A rule has force of law.
okay.
So if we collectively as a town don't follow our committee appointment policy, there isn't a harm. But if somebody's violating the rules around Title V, there's a harm. And that's why rules have force of law.
Okay.
Next section about the select board. This has almost in this exact form been present for several years, that basically says you can be called the select board and not the Board of Selectmen. Mass General Law refers to the Board of Selectmen, and all powers are conveyed to the Board of Selectmen. What this does is it says you can be called select board. But 2 words for purposes of these bylaws and otherwise are the 2 words added by town council at the last review. What those 2 words mean is you can always be called you can always be called select board. You don't need to have something special that sometimes you're the select board and sometimes you're the Board of Selectmen, depending upon the exact action you're taking. Those and otherwise words mean that you are always referenced as the select board. At least as far as the town is concerned. Questions on that section? Because now I'm going to say the exact same thing again about the treasurer-collector. There was a special act of the legislature, I forget when, that created the office of, in the special act, treasurer-town collector. That's what that section of Mass General Law calls Becky's position. That is law. So just like Mass General Law says Board of Selectmen and we're changing the term locally, we're doing the same thing here. Becky's position with this is treasurer collector, not treasurer-town collector. And the words are virtually identical between the 2 sections, it's just 2 offices. Moving on. Severability. If you were to go through our bylaws today, you'll find some have a severability clause and some do not. What the severability clause is, you take this giant bylaw, and if a court says this section is wrong and can't be enforced, it's stricken, the rest of the bylaw stays intact. That's what severability is all about. What we did is we said enough of this. Every bylaw needs a severability clause, and we extended it not just to bylaws, but also to regulations and rules. Nothing, now zoning is its own thing, it's gonna have to go separately, but any town department that writes a regulation automatically will have severability in it. And any rule. We have it once, it's in all of them implicitly, and we're done with that. Questions or comments on general provision? I will point out only, very quickly, this last section, it is not part of the bylaw text. That's our history. Every bylaw will have this section at the bottom of the very last page that says, here's what's happened to this bylaw over time. And you can even see we have placeholder for when we go. Let me see, is there anything else? I'm just going through some notes. No, covered. Now I need to go down here and do up. That's what I need to see there. I need to make that active so I can go to appointed committees. Again, we go back to history. I don't remember when it happened. It was a long time ago that the town passed a bylaw that that said that any committee member must be a resident of must be a registered voter of the town. And that bylaw was never sent to the Attorney General's office, so it never had any force. Until Anita discovered it one day and sent it in and went through the process. And we have since modified it a couple times, but the bylaw committee said, let's take a step back. It's residency and voter status is an important element. Let's not lose that. But there are a lot more things we should say about all the town committees. So we gathered them all up into this bylaw. Most of these are combinations of things that are in a variety of bylaws. We're just centralizing the location one so we don't have to say it for the Council on Aging and the Conservation Commission and every single commission, board, whatever. So, unless otherwise specified, this is the way we behave. Select board appoints, and there are exceptions in other bylaws for that. Committee members serve without pay, which should go without saying, but apparently it doesn't always. So each member shall serve until such member vacates the seat, the term expires, or a successor is appointed. So this is where we are making some things very clear. Somebody moves out of town, is no longer a registered voter, they vacated the seat, or just resigns because they don't have time for the committee. We've seen that enough times. When they vacate, they're no longer a member of the committee, it goes up, somebody has to appoint, blah, 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 blah. Next one, the term expires. So I was recently reappointed to the Cable Advisory Committee. When my term expired, my seat was vacant unless, and this is where it gets fuzzy because of Mass General Law, and certain committees have Mass General Law that talk about carryover appointments. That somebody who isn't reappointed on some committees still serves on the committee until a replacement is appointed by the appointing authority. It's not all committees. It all depends. It's gross and it's ugly. So we actually said, and this is important, or a successor is appointed, so that whenever a successor is appointed, that previous holder of that seat is no longer a member of that committee. Whether it's June 15 of the year or July 30th of the year, it doesn't matter. The carryover appointment goes away at the moment of appointment of the successor.
Is that something where there should still be a temporary appointment? If they're willing to, like, why wouldn't they
So I think
seek
sometimes,
reappointment? I mean, is it because they can't do a full term?
Go ahead,
I was
Leah,
gonna
I'm
say,
sorry.
sometimes we've had in the past where people won't go through the requirements of getting the recommendation of the chair or even submitting a letter of interest, that they're kind of fine to continue to serve, but they're not gonna do any work to continue to serve. And so we've had that sometimes where it's like pulling teeth to try to get even an acknowledgement that they're interested in serving. It sometimes can affect quorum issues and everything, and so I think historically, I think have not always been great about appointing by our July 1st deadline. And so then we would just assume that those appointments, the previous appointments are still carried over until we get to the appointments, if it's middle of July or something. And I think that was the big one, right, Peter?
There's that one, there are also funny concerns if the select board just doesn't want to reappoint the person, but hasn't yet
Found a replacement.
found a
or-
replacement that they're going to appoint. Whether or not that person can continue to serve is a function of Mass General Law for that particular, like the Conservation Commission explicitly has carryover provisions. Most of the time, we would hope would always be friendly. It is not always friendly. Actually, I do want to back up. You'll notice the title of this is Appointed Committees. Leah, you may or may not remember that when we went over this last time, we talked about whether or not it should also cover elected committees. And town council said, no, don't screw around with elected people. Never do that. So this is appointed bodies only.
So the word committee goes back to the original general provisions. Okay.
Questions on that? So here's something that we decided to put in that we thought was a really good idea. Each committee shall annually elect its officers. What are the officers? Depends on what the committee wants to come up with. Some have chair, vice chair, treasurer, clerk. Some have chair only. The officers vary by commission or by committee, and we didn't want to rule that you must have this structure, because that felt wrong for us to dictate to FinCom what the structure must be. And a different word, each committee shall annually select a clerk. This is the Tamika case. Tamika is not a member of Conservation Commission, but she is our clerk, as she is for so many other members, so many other committees. So the clerk need not be a member of the committee. That's very important for Tamika. And she does her job, keep minutes, file them with the town clerk, the usuals.
I have a question on that.
Yes.
So where you had noted each committee shall annually elect its officers, each committee decides what officers they have. What if they choose not to have a clerk? Aren't we technically required to have meeting minutes posted for every meeting that is
Yes,
held?
and
how
frequently
it's-
the chair does that.
Okay,
And that's why it says that each committee shall annually select a clerk. It's stating that basically every committee must have a clerk. It doesn't
Must have
necessarily
one.
have to be a member,
okay,
like an elected
Yeah.
member of that,
okay.
And usually that's the least position people want to take. So,
Is there anything, the clerk is responsible to keep and timely file minutes of all meetings with the town clerk. There's
That's
a
right.
lot of committees in this town that don't have updated meeting minutes posted. Is there anything that can be done to?
Fast answer, I don't know. When this goes into effect, now, actually back up. That is already a requirement of a clerk of every committee by Mass General Law. So there's nothing, this is not saying anything new, it just says it's in bylaw. So when this passes, we could, if you really wanted to drive people nuts, you could say, your committee isn't, you're violating a bylaw, it's $100 a day until you file them. Which is, I admit it, it's a silly approach. I'm not saying it's the right way to go.
$5,000. Let's hit
Look,
it.
I discovered recently that one of my boards, the Earthworks Board, has not had minutes published by the town clerk for 4 years, which shocked the hell out of me because our clerk is very good. And she's looking into it, but I can't tell you where the process fell down for 4 years. I just know that it wasn't, to my knowledge, it wasn't intentional. And yeah, something fell down, but that's a process that can be worked through. If there is a body that does not meet its legal requirements, we'll talk about that as we move through this bylaw. Motherhood and apple pie, appointments to committees with staggered terms shall be arranged so that as nearly as practicable, an equal number of terms expire each year. If you have a 5-member board, it's 2-1, short of vacancies. It's just like elections. It's the same process. Expiring terms shall end at the conclusion of the fiscal year.
Ooh,
It's explicit. Now, again, some bylaws change that, FinCom specifically.
Again, unless otherwise noted, right?
Yeah.
Yeah, well, again, the introduction to all these rules is unless there's another law that says otherwise. Term of a member appointed to fill a vacancy shall end when the previous member's term will have ended.
That's if there's a vacancy mid-term.
Yes. So somebody vacate, moves July 4th.
Yeah.
Then the rest of that member's term, whether it be 1 year or 3 years, is filled by whoever is appointed. Here's a new one, taken directly from FinCom. When any member is absent from 5 consecutive committee meetings, except in the case of illness or other good cause, and upon majority vote of such committee, the member's seat shall be deemed vacant. Somebody doesn't show up to meetings, get them the hell out. Again, this comes straight from FinCom. Actually, the difference between the FinCom bylaw today and this is that they wanted, and upon majority vote of the committee, they want an explicit vote to kick somebody off, and I see the value in that. Because if the committee doesn't agree to kick somebody off, why are you going through the process anyway? Mm-hmm. And if there is good cause, you wouldn't want to kick them off. So I understand the process.
And I think now, even with the remote access ability, it's become less of an issue. I know there used to be a lot of issues around, for example, people would serve but travel or go away for
Yes.
half of the year, and they weren't physically able to be here for the meeting, so that they would miss essentially half of a year's meetings. Whereas now, with the ability to have remote access and Zoom capabilities, it's I haven't noticed it nearly as frequently as
I
10 years
agree,
ago.
as long as Mass General Law allows members to be remote, which is up sometime in 2025, which I expect it to be either be extended or there'll be a different open meeting law by then. I believe that and as long as the committee uses Zoom for remote access, and not all of them do. But yes, I think I agree with your fundamental assertion that remote access has been a really good thing for transparency and for availability in this town.
Is Zoom the only option?
Zoom is the only one we've accepted as a town. There was a policy that was adopted sometime last year that specifically mentions Zoom as what the town has chosen. We don't say that's the only thing you can use, but there are rules about what facilities have to be made available through whatever technology you're going to use. If we were to switch to Microsoft Teams, fine, same kind of thing. If you were switch to WebEx, or there's so many different. Or Google, whatever the Google Meet is. They're all feasible as long as they have the main requirements, that's fine, and as long as it's published in the agenda, because another part of our policy is if you make a remote meeting attendance possible for a committee member, you must make it available to the public as a whole. That is not part of Mass General Law, and in my opinion, it's a great lack of Mass General Law. But
Is or is not?
it is not in Mass General Law, but it is in the policy adopted by the Select Board last year.
And I think the thought behind specifically saying Zoom was because it was going to be fee-based no matter what, and so rather
Right.
than have some groups wanting to do Zoom and some groups wanting to do Teams and some groups wanting to do Google Meet, and because of the length of the meetings and the recordings and everything, there would be fees associated with all of those, so rather than having a whole bunch of different technology options, it was thought to just pick one and make sure everybody had access and was comfortable using it, and it worked with cable and everything to be able to carry that.
Well,
But it's not required.
Zoom is required for a few committees. Select Board, Conservation Commission, Planning Board, FinCom are the four that come to mind instantly, and I don't remember if there's a fifth. I'd have to go back to the policy that I wrote, because I just don't remember it anymore,
And
but
that was definitely a conversation in the policy, and as we start to review policies, we can maybe have that conversation again, because there was conversation, should all elected boards be televised or have Zoom access, and then should any boards that are having financial discussions have Zoom access, should any board that is kind of a policy heavy board or enforcement heavy board have, so how did we, like, how to draw the line, because
Gotta make sure we have people to film this.
exactly.
Right.
So, and space that can handle the internet, at minimum, the internet requirements for Zoom. Like Wood Studio, for example, I don't think it's been updated, Wood Studio was not conducive to having remote access because there's no internet over there, the Wi-Fi signal is not strong enough to have reliable access, so.
right, I do know that there were some meetings, maybe it was the 300th committee early in its days, I don't remember exactly, but I remember hearing that there are always Zoom meetings over there because somebody brought a telephone, a cell phone box they could use as Wi-Fi, and that's how they got it. That's how they got Zoom to work in that space, but it's not something the town supports.
Okay.
Okay, moving on, registered voter requirement. This is the core of the original bylaw that we took from this. Everyone must be a registered voter of the town, and when it made the book, it created the word "from" into 2 words, I don't know why. From date of appointment through the appointment term. If you register to vote somewhere else or you move, you're not on the committee anymore. And town employees may be appointed to serve on committees as voting or non-voting member without regard to voter registration status. This covered some of the weirdo cases where we had the assessor Diane on the solar committee. Essential for that committee to serve with her knowledge base. So there are town employees may serve even if they're not registered in town. Few and far between, should be the exception, not the rule. All disclaimers apply.
I do have a question.
Yes.
As an example, now I don't know why he hasn't updated it yet, but I have a neighbor of mine who is ex-military.
Mm-hmm.
They've lived in town for almost 5 years now, but he was still registered to vote in Texas. And was not able to sign my nomination papers when I ran for the select
Sure.
board. Is there any exception to that, or is it strictly just across the board, whatever your circumstances, if you're registered elsewhere?
It is, if you are registered elsewhere, you're not a committee member in town. There were discussions about exceptions, and they were effectively all shot down, either by the committee itself or by previous iterations of the select board. We talked a lot about exceptions, and because we had specific examples we were thinking of. Hey, wouldn't it be great if this person could still serve on that committee because he's a longtime town resident, and yeah, he moved out of town, but he can still help us? And the answer at the end of the day was no.
I think the select board, and since I've been on, we haven't talked about the residency and voter requirement, but it's come up before. And I think the select board has generally, depending on the committee, 4th of July, 300th, and economic development are 3 that come to mind instantaneously, have been amenable to having people serve kind of ex officio, almost as consultants or something, because they either have deep ties to the community through residency, years of residency or whatever, or for economic development, hold a strong economic position in town. that could offer insight and guidance in that route, so.
Now, I am personally, I'm not a fan of making such people official members of the committee. Because anybody, any member of the public can show up at any public meeting at all. So I would think that I would consider such a person somebody who's showing up, who happens to be giving advice and guidance. Okay, that's fine. They're just, only members can vote. And although this discusses non-voting members, that's not really discussed elsewhere. Non-voting members are a really tough thing because they're not really members if they can't vote.
And I'm gonna ask a really dumb question, and I'm sorry, but for residents for a town meeting, in order to vote in town meeting for warrant articles, do you have to be registered? to
Yes?
That's in order to get a clicker, you check in, and it's similar when you go to the polling places and
Okay.
you check in and they check you in. Now they're
Yep.
using the iPads, and in order to get a clicker, you have to be a registered voter in
You
the
have to be
system.
on the voting rolls, absolutely. So I don't know if part of Tamika's process, and I'm not sure Tamika wants to speak up or not, I don't know if her process today is check with the town clerk to make sure they're a voting member. Probably ought to be. But if not, it's a question of who gets the responsibility of doing that check. Should it be the chair who's suggesting this person? Should it be, I don't know. I don't know what the right, I know that we should try to enforce a process, certainly not in bylaw about it.
I can think of from the one experience that I lived through is that I really think it should fall to the select board office, and sorry Tamika, but that gets, one of the check marks is just to confirm that anyone that's showing interest is a registered voter, so that anybody that's coming before us, and I think more so of when there's slightly potentially more contentious appointments that could be made, just to make sure that anybody that's coming before the board has been checked on that, since that's a requirement, so.
I would agree.
And by the way, to complete the circuit with elected officials, every elected official must be a registered voter. You can't get the papers unless you're a registered voter. Now, it's an interesting question, if there were a write-in candidate who was not registered, what would happen? I think that person cannot be qualified for office. That'd be my
I think
guess.
that they can't be qualified, I think.
I think that's it exactly, because then it's up to town clerk to qualify, and it is a requirement of elected office in this state. Okay, moving on. Whole new section. Today, you find, I'll use me this time. I've committed a heinous legal act, a felony. I've committed violence upon another person, and I've been convicted. You folks can't kick me off any boards. You don't have the power,
As it is right now.
as it is today. Yes, it's a specific grotesque example. But if the select board finds someone is not doing the duty, we talk about 5 members, 5 consecutive meetings, and the committee themselves can vote them off. But if they don't take an action, it might fall upon the select board to take an action in that case. It's just, now, there is for cause, and that is an important thing, and you have to be able to justify the decision to remove someone. And it can't be, we don't like your decision on this issue before the board or the committee. There has to be actual cause. But assuming that there is, then this lays out how that process takes place, where it says the appointing authority, and for most committees, that is the select board. This is the process you have to follow. Simple majority of the appointing authority, so in this case, we'll just say select board. You have to give a hearing. Has to be before you do a removal. Has to be given written notice 5 working days prior to the hearing. And by the way, there can include a notice of immediate suspension. So depending upon the circumstances, if you can justify that, it makes sense to do. The member at the hearing answers the charges. Now, he may have counsel in his place to do that answering, that's all fine. Now, this is a personnel matter. Fundamentally, because for certain cases in MGL, this committee member is an employee of the town. That makes this a personnel matter, and therefore, the hearing shall be held in executive session unless the member asks otherwise. Requests in writing, I believe, yes. The plan is you do it in executive because it's private. But if this person wants to make a public stink, he has the right. You have the hearing. Like all hearings, they can be continued multiple times. That's up to the appointing authority to determine. But once you've closed the hearing and you do your deliberation, and you make a decision, 3 days later, the member notified about the decision.
3 working days.
Yes, 3 working days.
The notification doesn't have to be done by anything specific?
It just says
Registered
in
mail,
writing.
not just.
It could theoretically, the problem with registered mail is ensuring delivery within 3 days. I would submit to you that you would use a constable for delivery. When you want specific timing, when you have a limited time to deliver written notice, you want to use a constable for that. But there's no law that says you have to do it that way. If you want to stick it in the mail with return receipt and all of that, sure, but you're taking the risk that that the decision won't be delivered in time for the 3 working days.
Is that MGL?
No.
That
Is what MGL? I should ask. Let me be clear. I'm answering your question.
The reason I said it's 3, could it be others or MGL specifically says 3?
MGL is nothing to say, is silent on this matter. We came up with 3 because, the committee as a whole decided on 3, because you want this to not fester. You want this done quickly. Once a decision is made, you want that if you want that person gone, you want that person gone quickly. If you want that person to stay, that person should be resuming duties as quickly as possible. The fewer days, the fewer problem. This is going to be a Rutland resident because they're serving on a committee, so they're a registered voter. We know where to find them, and constables are at the are available to us.
That's really a 3-day choice. You're looking at constable to do the job.
That is the most sure way to have that notice delivered.
And I will say, there was a lot of conversation about this and the timelines in our previous iterations and concerns as far as, and I think that that's why the, such notice may include a notice of suspension, because originally it was like, well, if we wanna remove someone, if the appointed authority wants to remove someone for a significant reason, but they're allowed to continue to serve, then that creates an issue. Similar, we don't want it to be dragged on forever and ever.
Right.
And so, it was, I think originally 3 days, I think even though the days were different and we decided on to do working days. So there was a lot of conversation about this particular piece to make sure that it wasn't just a swing at the political whim of the board.
Yeah.
And also that it was not, if there was legitimate reason to remove someone or to have the conversation about removal, that person wasn't able to continue to serve and do detrimental damage
That's right.
while that process was undergoing.
Okay.
If that makes sense.
Yeah, it does.
And I think that that's captured here, but having fresh sets of eyes on it is.
Absolutely.
It's just, I'm thinking, if it has to be in the hands of the individual in 3 days, it's like, how do you make that happen? You could send it FedEx guaranteed, that's not guaranteed. You can send it, so constable really is,
Yeah, and a constable doesn't have to be, for it to legally be delivered, doesn't have to be in
I was
hand.
just gonna say, does it have to be in
Constable can
person?
stamp it on the door and the state
it in the
recognizes that as
mailbox.
delivered.
well, that's what I'm saying, but it has to
Yeah.
be notified in writing of the decision within 3 working days, so. Okay.
So you will also notice that, I mean, there is a timeline here. It doesn't talk about when something happened that makes you think that someone should be removed or suspended. That's a virtually infinite amount of time. It's only when the appointing authority decides it's time to remove, you have to decide when the hearing's going to be, and that's got to be at least 5 days later, 6 days, because you've got to write the letter and get it, write the notice to the member.
Here, Leah?
Yeah.
In your previous iterations, did you discuss what happens if, does the process start over or whatever, if you don't deliver that within 3 working days? What happens?
It's never explicitly said, but it is based on the wording as it is. I would suspect that you have not met the needs, the requirements of the bylaw to remove, so you start again.
I have 2 questions.
Yes.
Is there anything that needs to be noted here? So we're talking about the appointing authority having the authority to remove the committee member. In most cases, that's gonna be the select board.
Yep.
How does the communication of said committee member, I'm assuming it's that committee is deciding, can they, I guess maybe that's a question, can they, a committee?
The fast answer is yes. A committee can say, here's the cause which we are asking you to remove, or it could be you, or it could be you, the appointing
initiate.
authority acting on your own.
Okay, so is there anything that we need to add that states a committee can initiate the process, or is it the select board, like, is that just informal? The chair of a committee would come to the select board and,
We can put something in if you want it, and I think that I wouldn't say it doesn't belong, and start with that. I understand your point about highlighting that a committee may, it's a weirdo question,
yeah,
because with all the politics in all committees, I don't know that you would ever, unless one member were particularly reviled, that the committee as a whole is not, in general, likely to stick themselves up to say, I want this person gone. There are specific cases where I can think of it, but
so this is a saying that without input from said committee,
yes,
this board could still decide.
absolutely. The
Not-
appointing authority can
Okay.
always decide that a committee member needs to be removed
All right, I just
for cause.
wanna make sure it's
Yep.
something where anybody on one of those committees could approach the select board, obviously with concerns.
It could be a citizen who approaches.
Okay,
It
yeah.
could be,
And I would
it could
imagine,
literally be anybody could ask.
and I would imagine that in most cases, it would be something that at least it's been on, somebody has heard about it and has,
Yeah.
Can either watch the meetings or look at minutes or whatever.
Yeah.
Would that be an executive session? I mean, I can't imagine an open meeting where somebody's coming in here and say, we wanna get rid of so-and-so. Might be, but I'm just, where does that occur?
I think,
I think it would have to be executive, because it is, at the end of the day, a personnel decision.
and I think ultimately it would be initiated by going either through one of us that is brought then to the TA's attention to figure out how to pass it, pass it along, and probably then an executive session for that, and then the executive session for the hearing, unless the member is asking to have it in open session. I had one question, should there be something in, we're notifying the member within 3 working days of the action, the decision from the hearing? Should there be comment in there about, and the committee will be notified of the action, because I think there could be cases where someone is still potentially attending meetings that,
Agreed that the committee needs to be notified so that they know that a person is no
is
longer
no
a
longer
member.
voting, right? Like they can attend, I would assume, unless
Yeah,
there's some
absolutely.
sort of restraining concern, but otherwise, but that they're not, that they are no longer a voting.
They're no longer a member, which means they don't have the rights of a member. They don't have right to speak and be recognized by the chair necessarily.
And I have one more question, sorry.
Yes, please, no, that's okay.
Is there, what about anything as far as reappointment to the committee or another committee?
And we are purposely silent on that point.
Okay.
It is up to, each appointing authority to determine if a person should serve on the committee they've requested to go onto. And the only difference many differences, but a primary difference between removal and appointing is removal has to be for cause, and you don't need cause to not appoint someone. The board can decide to leave a seat vacant. That is entirely within the appointing authority's purview.
Okay.
If they feel the person is not qualified, you don't have to list reasons for it. To remove, you have to list reasons.
But don't we also get back then, Peter, to, it should be the job of the chair of the committee to nominate the interested individual with his letter of intent. So it has to go that process before it gets to us, or we refer them back to the chair of the committee if they have an interest.
So this is a
That's
policy.
policy, this is bylaw.
Okay.
The bylaw will be silent on the matter because I don't think there's value in writing that down for law.
Okay.
Well, I think that makes sense too, because you could have a case where if somebody's been removed, the chair may not have agreed with that and could still submit another
That's right.
recommendation, and then it would still need to come to us where we would decide yes or no.
It has happened that appointments have occurred without chair recommendations, that's happened.
We just did a couple, didn't we? We didn't
Yeah.
have.
Yeah, and and I'm not saying it's wrong, policy is just guidelines, right? I've already said that once. The appointing authority has to do what it thinks it should do, the most right thing for that committee, always.
That makes sense.
And I would argue that the appointing authority, if that were the case, could ask that decision is noted in select board's files, so that there's a history there if there's questions or
Well, I would probably go to personnel in Boston anyways. If that was an issue there where this guy who's getting kicked off one goes to another, so to speak,
Yeah.
it might be a personnel issue.
I think it's that's tough because that was part of my question about the town employee piece is there's a piece that, yes, they're considered town employees for their kind of
For conflict of interest, yep.
conflict of interest, and even for executive session purposes, because it's still the character and reputation of the person.
That's right.
Whereas they are not, they, to me, fall more under select board because we're the appointing authority than the town administrator as the hiring authority.
Right, they're not the
But-
employees of the town,
Yeah.
right?
But that's, I think, one of those murky areas, but.
It can certainly get fuzzy.
And this again is for appointed and only appointed, elected, we don't touch.
That's right.
That's its own.
We can have a whole nother discussion about elected committees. Removal is solely with the appointing authority. Nobody else can force it to happen. And whatever the appointing committee does, it's final. There's no appeal anywhere. They can't go to court to get back on. I mean, sure, they can bring a civil action, all kinds of things can happen, but come on. Okay, questions about appointed committees?
There could be multiple officers, if you will, dealing with appointment committees. And I'll reference where the moderator, and maybe Austin can address this, the moderator appoints the finance committee, but the select board has to approve it. So you now have
Well, hold
two-
on, the select board ratifies.
Well, it's the same thing, but
is it?
Webster's dictionary defines it as the same thing, basically.
Webster's
So-
a crappy dictionary, but
Okay,
let's move
but
on.
ratification, so now you have what we call two appointing authorities. One appoints, one ratifies. So do both of those individuals meet the definition of appointing authority?
The fast answer is, in the FinCom bylaw, the appointing authority is and is only the moderator. That's it. Now,
Purposes of removal.
we'll talk about removal because we have special ways to handle that for FinCom because they're a special board.
But I'm just thinking here, when we identify the appointing authority, is that definition, if you will, carried throughout all the bylaws?
Betcha.
Okay.
I don't know if this is the time where you want me to read.
Well, maybe we should as we go forward, because, the appointing authority is, who is the appointing authority? So that was my question.
So Harry had asked for a legal counsel's definition of ratification. So they responded and said ratification is the process of confirming or approving of an act that has been taken by the subordinate body. It is the formal agreement and confirmation of the appointment process. In this circumstance, if the bylaw or appointment were adopted, the appointment would not be final unless and until the appointment has been voted on by the select board. If the select board should not vote to ratify, then the appointment does not take place. It is likely under the circumstance that the select board would be the appointing authority, but obviously Dave wants to take another look at this specific bylaw to get a definite answer to this.
Well, you should also look at the new version of the FinCom bylaw that lays that out much more clearly than the current bylaw.
He did finalize it by saying,
Seemingly, to get on finance committee, I mean, the normal procedure is to file a letter of intent with the Board of Selectmen's office, right?
For FinCom? No.
No. It is for
FinCom,
everybody else.
yes, because the select board appoints all those other bodies.
Okay.
FinCom is at and I use this word lightly and I don't mean it's a light decision, but it is at the whim of the moderator, period.
and that's because FinCom is a committee of the legislative body rather than executive created committee.
So in other words, they don't even have to give intention or basic application type of thing to the moderator, right?
Correct. It's whatever the moderator decides the process is.
Okay, he did conclude with his
Yeah.
legal response. There can be issues, however, if there is a later decision to attempt to terminate the appointment, which I know is kind of what we're talking about now. So that's, I think, the lawyer's answer for however that may be, everything I told
That's
you may
right.
change.
Yeah, and I was, the reason, we had discussed this, the reason I wanted to that is because in the removal process, it says the appointing authority.
Mhm.
So in that case, because we're gonna be getting to that at some point, what the heck? No,
Hello, Chris, can you hear me?
no. Come on, oh, stupid thing.
Is there a bylaw for this?
Yeah.
Maybe we should have a bylaw that says no electronics at this table.
Turn the damn thing off, I don't know why it was here. So, if you look at the appointing authority, that if we have to ratify anything, basically if we say no, there's no appointment. If we say yes, there is an appointment. So, again, I come back to, it would seem like we're the ultimate appointment authority under ratification.
Hold on. Wait until we get to the FinCom bylaw because things aren't the same.
Well, okay,
Because if yes, you can still vote no.
right,
But if you don't take an action within sufficient time, you have constructively approved
right.
his appointment. So that's a very important difference.
Under the one we're gonna be getting into.
Yes.
So that's not hard cement right now.
It's not in effect right now.
Thank you, Austin, for checking into that. Appreciate it. Did clarify that.
15 minutes-ish. Let's see what we can get through for town meetings.
I love this one.
La 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 la. Dates, okay, so. The first one is pretty straightforward, except, well, it is straightforward, it's just there's a change. So let's start with the annual election of town officials, and all other matters to be decided by ballot shall be held each year in the second Monday in May. Exactly the same. Now we have new words. The spring town meeting, which used to say annual town meeting, because what we are proposing is 2 regularly scheduled town meetings. The May one, the spring one, is always, by law, the annual. The one that's in November, the fall town meeting, is a special. And any other town meetings that you folks call are all specials. But it is the committee's belief that there is value in having 2 scheduled throughout the year. That is not that unusual in towns. In fact, we found a number of places that use this nomenclature. And even when they don't use the spring and fall nomenclature, even when they call it annual and special, they still schedule 2. And in this town, having a spring and a fall regularly scheduled helps the town plan. So, spring town meeting wherein all business shall be considered except matters determined by ballot shall be held each year on the Saturday following. We're moving town meeting. We are proposing moving town meeting. The second Monday in May.
So, go ahead, Jen.
Why are we doing it on Saturday?
Because when I tried to move it away from Saturday, the town defeated it completely. It's my one bylaw loss in this
You're the one town in
town.
this district that does it on Saturday.
Yep.
Why? That's like the worst time when.
The select board entirely wanted it at the iteration when we put it up. Really wanted it on a weeknight, and we decided, I think on Monday, but I'm no longer certain, it's been too long. The town,
Town
And what was the reason?
torches and pitchforks, kids, the town does not want it moved from a Saturday.
Right.
Well, from what I understood, it was because that was the day, people don't work. They don't have to worry about babysitting and all that stuff, so they can get to the town meeting.
You still don't bring your kids on Saturday, so you still have to.
Well, I know, but one parent can stay home, but during the day, you're working, you come home, that was my
You put in the whole day of work, and then you got a 3-hour town meeting starting at 7 PM.
I think more
It's
people
once a
would.
That was,
year.
hey, I'm not saying
I am not
agreeing,
disagreeing.
I'm just saying, that was the.
Every other town meeting is during the weekday, it's at like 6 PM or 7 PM at night, and yeah, I understand it's a long day. I've been up since 3:45 this morning working, and I'm still here tonight.
I don't,
It's once a year.
Town meeting where it was discussed, there were, I think, either 3 or 4 nurses who stood up and said, well, we work on Saturdays,
Right.
okay?
Yeah.
So what's wrong with a weeknight?
the town voted, the town soundly defeated moving it away. There were a lot of other changes in that bylaw amendment that would have gone into place then, but the whole thing was defeated because it moved it from a Saturday night.
Yeah.
Well, from a Saturday, I should say, not even
How long
night.
ago was
Yep.
that?
4 years?
Uh,
5 years?
It was before I was on the board, but it was while I was in town, so it was more than 5 years ago.
It's when
but-
Sheila Dibb was chair. More than that, I don't remember. I can't play, I could find it if I went looking for it.
What was it always, I don't remember it always being a Saturday.
It was not all, I don't believe it always was a Saturday.
No.
The town has well,
I think,
actually, I'm not sure about that. I'm really not sure about the history of
I
that.
thought some of the conversation was not so much moving it from a Saturday, but that the voters didn't like the day that it was being proposed to be moved to. And I don't remember, and I think some of it was, again, the conversation before or after the election. And I don't, it's not fresh in my head at all, that conversation, but I remember, I'm not sure how much of it was that it was moving from a Saturday, but more to the timing of when it was going to be moved to.
My sense of it was, no Saturday, you can't move it off Saturday.
Well, it's not a hill I'm gonna die on, but
No.
I if it's been that many years, I would not be opposed to attempting to move it again if the board so
Yeah, the
decides.
dynamics of the town have changed dramatically
Oh, yeah.
over this time, so.
But
I'm not a problem with Monday.
Based on the history, I would submit that would be a separate amendment we want to do so that it can fail on its own and not impact the rest of the bylaw. Because again, there are things I don't want to have to go through again and again.
Yes.
And like, I would wanna go back and revisit the discussion around that to understand what all the pieces were, right, like, so,
All I can say is that, yeah, the Saturday kills me.
I had questions again, and I think that this is one where we kind of chase our tails before or after the election. And I think previously it had been hold it before the election because that's the board that is setting the warrant and knows everything and is going to be there to answer the questions, rather than have someone newly elected, or in this case, it would have been Tom and I that are sitting at that table that have the history there. I think there's maybe a little bit less concern of that now that the town has a town administrator, and the town administrator is involved in all of those conversations and everything. And oftentimes, the town administrator is the one addressing the questions with town council at the table. So, but for the board's conversation, that's the other piece, the Saturday piece and the timing before or after the election are the two big sticking points in town as a whole.
So let me tell you why we proposed moving it 1 week. Because the town clerk doesn't have time to do all the work that needs to be done for the election and for town meeting in those scarce hours that you have between them. Because Saturday's done. So you've got Sunday, which isn't supposed to be a working day, but has to be, and Monday, so you can get to the election on Tuesday. Actually, this is a Monday meeting. So you have Sunday, which isn't supposed to be a working day, with policy that, in fact, with MGL, that this town accepted at the last town meeting, Sunday is a holiday, and yet it requires a work on Sunday in order to set everything up for the election on Monday. It is not possible to do all the work that has to be done for town meeting and election in those few hours between them.
Yep. That was a point that was brought up.
And that,
Yep.
I guess my pushback there, and this is like, but my pushback is, as far as the workday, it's part of the job function and job description, that just is police and fire work their hours and are working. We have coverage on Sundays, and Austin's here tonight, and so it's a function of the position.
granted,
The other concern is moving it to 1 week after, is that if there's another contested election that takes a lot of time to sort, or a high voter turnout with a lot of write-ins or something, that the election that may not offer a lot of prep time either, that there's a lot of wrap up from town meeting that has to happen, but very little of it has to be absolutely done in order for the election to go off. I understand that it's an enormous amount of work to do both, as far as getting everything set up, but as far as what needs to be done and submitted from town meeting to what needs to be done and submitted on the election timeline is a little bit different, I think.
So are you thinking extended town meeting as even further out than 1 week after, or prior to?
So, I think that this is just some of the conversation that we've had. I mean, I think that if the argument is the amount of work that I think there are times that a week is not going to be enough. A week coming out of a big election, or another hotly contested or high voter.
but you also have to admit that those are, in the grand scheme of things, unusual circumstances. Anyone who brings up this thing that says, sometimes there are weird things with elections, yep, that is certainly true. And sometimes there are weird things at town meeting. The requirements of the job are the requirements of the job, certainly. The point that someone in the audience is, and I even know who, is gonna bring up is, if we have town meeting before election, then we can educate people at town meeting before just before they vote. And that is the best, although pretty weak argument for it, because if you haven't educated the people before the election, it doesn't matter when the town meeting is. If you don't make this past town meeting, if we hadn't had the Sunday sessions there, I mean, what would have happened? And that was all education. So how we educate people may need to be updated and adjusted, but to force so much work in a very short time period is unjust to the office in the town, in my opinion.
I share your opinion. I really do, yeah, because, you know, I've seen this over the years and really can understand just exactly what you're saying. In other words, you know, okay, so, yeah, this happens and that happens and so on and so forth. And then, you know, at that same town meeting where I just mentioned the nurses, I also now remember that there was a mother who stood up and said that her husband worked in the evenings, and so she had to get a babysitter. Well, it was not long after that we offered babysitting at town meetings, so yeah, things beget things, but.
And that, by the way, is not as consistent as I personally would like to see from the town in terms of offering babysitting at town meetings. It's a challenge to set it up, and I don't know who's responsible for doing it, but I can see value to the town of having more people present by offering babysitting, excuse me, than not have people be able to participate because of family circumstances.
I think it had started to take off, and then COVID hit.
And then COVID hit.
And then it's been slow to return.
Yeah, it did.
because-
This last time meeting it had it, if I remember right.
Yeah.
Which is good. I was happy to see that. Austin, I see you raising your hand a couple times.
Yeah, so I just have a question. So, I hope we don't get here, but I think we're getting there in terms of the amount of articles that we have on a warrant.
Mhm.
Does this language allow the select board to plan for multiple nights of town meeting?
There's nothing that would prevent that.
Okay, just it starts on that day and we can.
That's
go
right, because when you, well, yes, so it's a couple things that need to be scheduled correctly, because when you start, you know what the agenda is going to be for that much, and you know what agenda is going to be carried over. But what you have to determine as part of the adjournment of the first is that you have to know the exact date of continuation. So like Holden does it.
Location.
Yeah, and location. It's all got to be specified clearly, and that can all be managed. So there is nothing in here that would prevent town meeting to continue over multiple nights, planned or unplanned.
No, I know, but it's hard.
Nobody
to get
wants it.
people to go to one
Nobody
meeting.
wants it. But just like the current,
Yeah.
just like the current law, it ends at midnight, unless the town agrees to continue.
One more question, just about, in the previous community, we had the same challenge of, it was an elected board that had to present the warrant that was not put together by that board. What we did is we actually just changed the term start date for all boards and commissions to be July 1. So you knew that whatever board put together the warrant, they were still at that town meeting presenting that warrant. I just don't know if the committee considered that.
We had not.
Yeah.
I've even had discussion with some people in this room about why elected positions take office immediately upon qualification. And there is nothing that says that we can't write a bylaw that changes the start date. I don't know what that form would take. I don't know what effect it can have, because we'd have to dig into all the elected boards and all the MGL sections about them to make sure that we aren't creating conflict. But if we wanted to do that, we could. I don't know how the town would like dark horse candidates, people who are not serving in 2 months,
Right.
and what's going to drive them. I'm not saying it's wrong, I'm saying it's something to consider if we were going to try to adopt such a bylaw.
But those members
Dark
of
horse
those
is the wrong
boards
term, you know what I mean. Lame
still
duck
have
is
a
what I
lot
meant.
of authority in their discussions and membership of the board to put together the legislative agenda. And what goes on and what isn't on it. So that's, I think, just an overall challenge.
Yeah.
Is those dark horse
Yep.
candidates.
Yeah, lame duck, I used the
lame
wrong
duck.
term, I apologize. So I just want to finish this section. And then we'll talk about continuing. Spring is, as I said, proposed to be moved one day. And the fall is the third Thursday of November, always the week before Thanksgiving, which means people shouldn't be gone. And that's basically in the time frame where we usually have the fall town meeting anyway.
I know in the past the struggles have been getting cash certified by then.
Yep.
And that's, I think, been the hesitation is to putting, even when we're trying to set the fall town meeting as a board, we often are kind of fingers crossed and throwing our hopes at the wind and that cash will be certified. And more recently, it's been coming certified like much closer to town meeting, to the date of town meeting than we would like, because it really then impacts, since fall town meeting is generally where free cash.
Yeah, the free cash is
spent.
allocated, yeah.
It puts a real constraints on FinCom and Select Board and CIPC to determine how best to make the recommendations based on what's available, because if we're getting those numbers a few days before the meeting, it's not always possible or feasible to have a meeting posted to talk about and or enough time to post.
It always happens. It is a universal truth that fall town meeting is a gamble. Because you have to you, as the board that calls the town meeting, has to have faith it's going to be done whenever you call the meeting, period.
So does subsection 1 take care of that problem? If we want to change it?
Well, there are other things that have come up that allow it to change. Because with all the things that have happened in the last several years, we have the sections that are coming up talk about, oh, you want to move it? Okay, here's how you do it.
So, I mean, Austin, maybe if we know just going into it that it's, to me, fall town meeting is always during the week, and it's generally it's Monday, Tuesday, or Thursday, I think is my memory of when it's been held.
And the most recent history has been exclusively Thursdays.
Okay, so I think that this is less kind of controversial, but if we know looking at it, that the third Thursday of November, we need to have free cash certified, is there things that we can look back and deadlines that we can push or submit before, like earlier than we do or whatever, or put leverage at the state that we that's our date certain, that we need the numbers?
Well, so the state's actually they're pretty good, they're
Okay.
pretty quick. I think it's my understanding locally, it's just resources and staff have been,
Okay.
they've had a lot of responsibilities.
Okay.
So I think some of the changes that have been adopted in this budget should help with some of the
Okay,
cash estimation, so.
Okay.
I mean, cause that also, when you're certifying your free cash, you're also pushing your tax recap
Right.
process as well, so we really don't wanna be cutting it close like we have done in the past,
Right.
so. I think we should be pushing on that internally.
Right, and that was gonna be my
Sooner.
question, is what is the holdup? Is it something just not going through timely on our side, or is it state related, which it sounds like?
Yeah, they're pretty quick.
I know that recently the state has had concerns or questions about the water sewer enterprises and the mergers and everything, so that has definitely been more back and forth and everything, but that should be getting better as we move forward now, because I think the last iteration was tied up, I think, but it's good to know. So in my mind, this is less controversial than the spring town meeting date.
Right. And now, also, as Harry pointed out, I was thinking this is later, it's right here. You, FinCom, and the moderator get together and collectively decide if you want to reschedule or cancel it. Annual town meeting is an absolute positive requirement of Mass General Law. We are fixing the date. It's always that, whatever the date is. But fall is a special, it's optional.
Language, you have simple majority there.
Yes,
Is that mass language or is that town language?
It's town language, because this whole provision is town.
Well, the reason I ask is that if you look at a simple majority, the numbers don't come out right in my mind. I would like to see a 2/3 majority.
Well, if that's what you want, we can change that. What I will say is a simple majority, U5 plus FinCom 7 is 12, plus the moderator's 13.
Okay.
So,
Nothing
a
against
simple,
FinCom,
Yeah.
but if you take FinCom and the town moderator, it's over. No vote on the select board counts whatsoever.
that's the math.
But that's why I'm saying simple majority. I'd like to see something like a 2/3 that would still up it a little bit.
Yeah, good point.
May or may not be an issue, but I just didn't like that you talking 5 on the select board, 7 on finance and town moderator.
I see enough nodding of heads up and down. Okay, that's fine.
Go ahead, Austin.
And isn't right,
I guess my only question about that is, a special town meeting can also be called by residents. How many is it, 10, Peter?
I forget, it's something like that, sure. It's some number of residents, yeah.
So let's say you were overruled, you could get
Five of
board
us
members
or-
and 5 of your friends to call a special town meeting, and this bylaw could not overrule it anyways.
But would that meeting be to discuss warrant articles that were intended for the actual town meeting, or is it just to discuss with those 10 people?
So I think it's calling a special town meeting, right, Peter?
Right.
And then the select board has to set the.
Still has to set the warrant.
So it would still,
Yeah, I'm just trying to, I guess, finance the numbers a little bit, so hopefully
Yeah.
we don't have to go through all that stuff. Make it a little, if we're gonna change something, it should be a little more difficult to change a Thursday or November meeting. And not just, I mean, the select board might feel, you know what, we wanna change it, and finance and town moderators, no, we don't, we're all set, we got it. Well,
and if there's that much, I mean, there really should be 2/3 agreement to cancel a meeting like that. I mean, if there's that much division, half and half disagree, then
yeah, it doesn't make it a huge
there's something
difference,
else that needs to be talked about there.
but it does make enough difference that
Yeah.
initial 1 or 2 votes have to come together
agree.
to do that.
I agree.
Yeah. That's,
Easy, sure. But there are also words here, timing is everything, prior to posting of the warrant. So it's not, this is not a last minute decision you can make.
I mean, I would hope, working together, that it wouldn't be an issue. Everything is out there.
Because
now.
again, the biggest issue, and hopefully you collectively would all agree that free cash won't be available. And if you know that in advance, you can plan. If something comes up at the last minute is last minute, and then, sorry. And for that matter, things could really get interesting anyway, because if it turns out that free cash weren't available, then the moderator can open the meeting and can then call for adjournment to another date. But that's the town moderator's responsibility under town meeting time and general law.
currently town moderator is the one, cause I think there's been one case for this fall town meeting that we were supposed to be getting a storm or something, or was it coming out of COVID maybe? There was a uptick or something, and the town moderator postponed it to a date uncertain by like 2 weeks or something.
Right, so you have to be careful about understanding the special rules that were enacted because of COVID
That's what-
versus the general state. There are lots of things that we could do under the COVID emergency. By Mass General Law, town meeting shall be in the geographic limits of the town. And yet, there was that meeting we had at Wachusett
guess my
because of the COVID
My
regs.
question is there currently an MGL does town moderator have any authority to, I'm not worried, I'm fine with 2/3 to cancel, but I'm looking at reschedule if we're looking at a storm, something that, is there anything currently in Mass General Law?
Not until the moderator has control once the town meeting is in session. And until then, town moderator can't do anything,
Okay, that's fine then. That's fine.
subject to what we do right in this bylaw.
Oh, but
It's
that's
like I
fine.
have teas or something coming up.
I wanna try to move on, but for me personally, I'm not 100% sold on the second Monday of May for the annual. I do wanna go back and better understand the conversation around the vote as to why moving it from a Saturday or what the proposed day was, and better understand that. So I would like to earmark, that's a piece that I would like to earmark to come back to after
Sure.
we better understand as a board that piece, because I remember there was a lot of conversation and everything, and so, is that okay?
I think basically one of the select board members, I believe at that time, made the statement that, okay, so if the election is held after the town meeting, before the town meeting, then an elected member of the board may have to go into and support a budget that he or she did not believe in. Okay? That was one of the arguments that I remember.
And that is, by the way it used to be in this town.
Yeah.
It used to always be election, and then
Election.
town meeting. That was only changed some few numbers of years ago. I could look it up if I were
Right.
that interested, that it switched. But I'm still not sure that it's more than a specious argument with a town administrator who continues across elections. And by the way, for
And
the other people who are gonna support the budget, the FinCom, who really have to do more explaining than the select board does.
And the clickers.
Clickers help. I think there's a lot going on that we could say, but
The debate on that is quieted down, but it was
Yep.
pretty heated at one point.
I see the question forming, I'm just not sure what it
No, I'm
is.
looking at, I don't think there is a question.
Okay,
Okay,
so we're at 1:15. I'm gonna propose we stop here and continue because I have another topic that I should have covered before we began, which I forgot about. And that is, actually, first let me be a good doobie and stop sharing. And that is scheduling. Let me also press that so you can see it. Not that there's anybody there to look at, but. Way back when we had my first introduction to you folks, I suggested that November was feasible because it's all based upon what's happening with the special legislation. I don't think November is feasible no matter what. Because there's just too much process and too many vacations and not enough time to do everything that needs to be done. 4 weeks ago, I was saying words like, we should be thinking about a February special that's just bylaws. But that's gonna still depend upon the special legislation. 4 weeks ago, I would have thought it's a slam dunk. And then 2 meetings ago, you folks had to adopt a different set of wording for the legislation, which means that part of the process in the legislature has to start again to some degree. It's not completely from scratch, but, so I don't know. I'm not saying February is not feasible. I honestly have no idea. Another idea that I had recently that I would like you to at least consider is a special town meeting 1 week before annual that's just bylaws. In all the cases, I'm going to suggest a special town meeting just for bylaws. Because I think that doing it at annual is creating nothing but
Too much.
We'll
a
end up
very,
continuing
very,
this.
very, very long meeting that could easily
Yeah.
go over midnight between budget and bylaws.
And I agree, I also agree having it as a target, if if we're doing it off of the annual town meeting, having it a dedicated target, well advertised,
Mhm.
outreach, publicity, everything, that it's for bylaws, and really get people there for bylaws and not just, there's a town meeting for bylaws, but really get the importance of it out. And that's the only business that'll be conducted there, I think.
I think it makes sense.
I would hope so. And there's only so much control we have over that. A very short open and close. There's no way to prevent a citizen petition, but again, if we set it up appropriately, then I think we can limit everything else. As much as we can, you know? We only have so much control. So, Austin, I don't know if you have any thoughts about the legislation and how fast you think it will move, given the state that it's in.
That's funny you mentioned, I was just looking, so actually today, the Senate sent it to third reading, which means it will go to the committee on third reading. And once it's through that committee, things go pretty quickly once it's on that third reading.
Great. Well, that raises my hopes for a February-ish. And I only say February because we've had enough February in the history of the town. February is not uncommon for specials.
And the special legislation is the select board's
Select Board and Board of Public Works.
that needs to go through
Yes.
before we address select board and board of public works.
And everything that depends on those.
So I can say personally, I'm okay kind of looking towards seeing how things track and working towards February, March timeframe. And then if it seems like it's gonna slow, the special legislation is taking longer, then we look to push it out beyond that. But if we, as a board, can work to, and not just with this, but also the public information sessions and everything also, can work to look towards kind of a February timeline. If we have to delay it because of extenuating circumstances, a bulk of the work has already been done, and so it's just the extending.
Yeah, I'm in favor of this process moving forward as quickly as we can, so we are ready as quickly as we can be. Because again, there's this, any changes, legal review, some changes have to go back to subject matter experts, all of that. And some of these haven't been through, the later ones, I haven't been through a lot of review. In fact, you folks have never seen them. And in fact, no, the subject matter experts have all seen the ones that we're finished with. I will warn you now that that one of our bylaw changes, in order to be effective, needs to have a zoning bylaw change as well.
Is planning board zoning bylaw subcommittee aware of that and also beginning to work on whatever that may be?
We've had discussions about a couple things, and in fact, with permission of the planning board, the ad hoc bylaw committee is going to take a swing at the couple changes that we've been talking about and present it to the planning board and their subcommittee for approval. But just, I'm in favor of getting stuff done as early as we can so we have less holdup. The zoning change does not impact anything else. So it could actually be in November if we were ready in time. And it wouldn't impact anything in the general bylaws today, except actually make one part that we have, the word I'm looking for is legal.
But I would caution to make sure that it's done thoroughly and well and presented thoroughly and well, because if it fails in a November town meeting, it can't be brought back for two years, and then that puts that piece. So.
Well, we also believe that, well, of the two things that we've been talking about, the one that's important in the general bylaws is not only non-controversial, we think the town will see benefit in it. and we can
So
explain
the town
that.
has surprised us before.
Yep, town surprises lots, yep,
See
absolutely.
when a zoning change benefits the town, I really do.
Not
In
having to
terms
go,
of-
before, not having to go before the ZBA for a personal kennel.
Oh, okay.
Zoning bylaw says every kennel requires a ZBA approval. But our general bylaw says that personal kennels do not require ZBA approval, but since zoning bylaw always trumps general bylaw, we have a conflict and zoning bylaw wins, which means that every personal kennel is supposed to have ZBA approval, which doesn't freaking make sense.
And technically, any household with more than 3 dogs is considered a kennel?
I think it's more than 4.
Oh, I thought, but it's.
I
mean,
forget,
it's-
there is a fairly small number,
Right,
yes.
I was like, it's, given that a lot of people have a lot of property and that it's not necessarily a small, like an unheard of.
That wasn't addressed to you, Norm.
What?
Planning board, zoning comment was not addressed to you.
So does that work for the board and to kind of work on that timeline, that we look towards a February-ish special town meeting?
I think it's doable, depending on how many meetings we have.
Right,
I think we
Yeah.
need to keep the momentum going, just
right.
try and get through, like you
Right.
said, so whatever happens, we're ready for it. If we have to extend it a little bit, we're still prepared.
So.
I'd also like to get a quick read from the group. How did you feel about this? Too much information, too little, too slow, too fast? I mean, I'm just, so I can adjust for the next, any adjustments I need to make for the next meeting on Monday, just let me know. We don't have to have a vote or anything about it right now.
No, I thought it was a good meeting.
So for me, I've seen a lot of it, so I felt like it was a little slow for me, but I think that there's value to having it go a little bit slow to have the conversation, and for the public that is watching or going to go back and watch or anything also. So it's a little bit slower than I was anticipating, but I think that there's value to it, especially given that I think on the board when we discussed any of these, I might have been the only one that kind of
I
had
don't-
these discussions, so I think it was okay.
I think there's gonna be some times when we're gonna get 3 done, 2 done, and some
Yeah.
when we get 6 or 8 done.
Mhm.
'Cause that's
I
just the
agree.
way the bylaws are gonna be,
Well,
Yeah.
you know?
I said it before, the general provisions of the foundation, government is that next layer directly above it, and that feeds into all the others. So I think we're approaching it the most right way. Especially as you start seeing later bylaws interact with each other. It can get a little tricky, so we wanna make sure we get it right.
And I would just ask for any of us that hear kind of conversations around town or engage in conversations about people having concerns about these, that we make note and kind of get them to Austin and Tamika to collate for us, so that we know. I mean, I've heard kind of chatter about the fingerprinting bylaw already, that, you know, how that either should or shouldn't continue or whatever. And so I think that there is value to kind of keeping a pulse on what the community is saying around us. And either investigating more or having the conversations or whatever, so.
So, and the other thing that I will point out is that some people have objections based upon previous iterations of the bylaws. So their information, I've actually pointedly told a couple people, I know you had objections here, look at it now and let me know if there's something you still object to.
I know with some of the,
See, yeah.
some of the older board members that I've had conversations with, I feel like people get scared when you talk about this, cause they think it's a power grab a lot of times. As opposed to streamlining it, the government, to make it work.
Yeah.
And that's the discussion I've had with some, even though I'm extremely new at this. I've tried to tell people, my opinion is, we've gotta try and streamline Rutland's government to work
Yes.
for everybody.
And furthermore, I mean, I've said it a long time ago, I'll say it again right now. The intent of this is not to change the government to fit the bylaws. is to make the bylaws fit how the town works. I think of it as nothing more than describing or documenting what we actually do as opposed to what the bylaws say today. The intent is not to have wholesale changes to the way we do work. Yes, I will admit, town meeting from this month, Saturday to that Saturday, that is a change, but I can't call it a huge earth-shattering change. Scheduling a fall town meeting regularly is a change, but it's not a big change. And it really is conforming with the way the town has acted recently. So, yes, Harry, you're exactly right. There's always fear with change. Always. And part of what we in the bylaw committee have to do in publicizing this is saying, yeah, there are a lot of words that are changing, but there's not a lot of effect that's changing.
I think that Norman will agree with me that over the years, we have both seen a lot of the things that are being brought up here now with the bylaw changes and kind of figured, yeah, there was probably a better way to do this. Yeah.
Yeah.
So, this is what we're looking at, and I'm not having a problem with where we're going so far.
This is the side effect of not having a holistic view of the body of bylaws for 72 years so far. Some of them haven't changed since 1941 when they were passed.
Yeah.
Nobody's looked at them until somebody said, oh, we need to change the order of town meeting and election. Oh no, something comes up and somebody does a spot change and I see no evidence that people have looked at all the bylaws.
I think it's valuable from what I see, because at some point, we're gonna have to go to a charter.
Absolutely.
If we do that, this board has done a lot of hard work then to get it ready for the next boards or whatever to be able to implement that charter.
Amen to that, yeah.
Yep, charter's a very big deal, and it's also a very long process, and I agree that there is value along with all the pain that comes with the charter.
Oh, yes. I was part of a discussion on that some years ago, going to a charter. And it kind of died on the vine because once they started finding out just what it entailed, okay, people lost interest, so.
Yes, I have said this out loud. We have set up a lot of the bylaws so they could be imported into a charter virtually as is for a starting point, and then all you need to do is add all the stuff that's missing. It's like, there's a lot missing, because there's a lot we don't, that was not charter ready. But having something is a whole lot better than having nothing. And somebody says, if the decision of the Charter Commission is, we should go to a town manager instead of a town administrator. Okay, yeah, we've wasted. We have used time to write a town administrator bylaw that'll be in effect for 3 years until the charter gets passed, or whatever. Okay, that's whatever changes the Charter Commission decides upon. That's up to them to decide. I wouldn't want to interfere.
I hate to do this, but can I make a motion to end
would.
the meeting?
Second.
A motion to adjourn?
Nothing against you, but.
No, let's talk. It's past time. I can get off my soapbox, it's okay.
So Tamika, that was a motion by Harry and a second by Tom. I will take a roll call. Harry?
Second, aye.
Not tonight.
Ledger eye.
Galvin, aye.
Whitman, I with appreciation. Thank you, Peter and Norm and
Yeah,
all of
thanks.
the bylaws
Yes.
subcommittee. We are adjourned at 8:29. Thank you.